the legal process of obtaining registered and lawful ownership of fixed property, including improved and unimproved land, houses, farms, flats, as well as the registration of bonds and other rights of fixed properties, including servitudes, usufructs, and the like. The transfer process. While the transfer process follows a series of successive stages, the time period involved varies considerably. Generally, the following guidelines apply. Cash registration might take approximately 6 weeks. Within normal circumstances, including bond approval, approximately another 8 weeks. If conditionally upon the sale of a purchaser's property, within 30 days, approximately 12 weeks. So it is important for you as an agent to know that you must advise your purchaser, even if he tries to sell his own property, maybe it's advisable in that instance first to sell his property before they made an offer to purchase. And if I take an offer to purchase in subject to such a clause, we put in that clause to say that the seller does not take his property out of the market. Otherwise, because most of the times the sellers are giving you the mandate, so you are working with the sellers and they pay your commission, so you must also take their interest at heart as well. Stage 1, it is the purchase, it's the sale of the property. So you take the client out and they do a written deed of sale, and that is basically the first stage. You get it accepted and there you go on first stage. Stage 2, the purchaser makes an initial payment deposit and receives a copy of the title deed for his records. As does the seller. Simultaneously, the transferring attorney is furnished with the original deed agreement of sale to enable him to draw up his documents, and a copy is filed by the state agency. Stage 3, it is a bond application and approval. The buyer applies for a bond with the bank. Once a bond has been granted by the bank, it advises the bond attorney to register the bond. If the bank requests it, fumigation may be instructed to inspect the property for infestation by beetle. Also, if the seller is not in possession of electrical certificate, one must be obtained. Stage 4 is the actual property transfer. The documents required to enable transfer to be passed, power of attorney conferred upon the conveyancing attorney, transfer duty declaration are drawn up by the transferring attorney. The title deed and bond cancellation figures are requested from the bank, which currently has a bond over the property. Stage 5, rights clearance certificate and transfer documentation. A rights clearance certificate, a document stating that all rights and taxes for the current year have been paid, is obtained from the municipality by the transferring attorney. The bond attorney advises the transferring attorney of the amount available for guarantees and requests a draft deed of transfer and guarantee requirements. But you must also advise your sellers, do they know that where is the title deed? If they know where's the title deed, maybe they purchase the property cash, then they are in the title deed is in their hands, and then they must make it available for the transferring attorney, because without the original title deed, he cannot register. The cancellation attorney is requested to cancel the seller's bond, receipt of guarantee for the amount owing. Okay, the buyer pays the transfer cost and the transferring attorney pays the rates and taxes, and the transfer duty to the receiver of revenue and the transfer duty receipt is issued. The attorney needs that transfer receipt before they can submit registration. After registration, the title deed becomes available after about 2 months from the time of registration. What you must also advise your clients is that, especially your sellers, that normally the transferring attorney is paying the rates and taxes for a period for about 6 months. So say, for instance, you register within the next 3 months, then there's a 3 months money in the municipality's account, which they have to pay, and they only pay back with the transferring attorney. So the transferring attorney must reconcile the account and then pay the seller out the portion that belongs to him, either or, and the seller, the purchaser. Any questions to this regard? Okay, the property transfer, the property registration process. Number one is the transfer receive signed contract, the deed search. They open a file, they control the information, and they send the letters to all the parties. And stage two is the bond approval, cancellation figures, and title deed request. Request for municipality clearance certificate for rights and taxes, drawing up of transferring documents, arrangement for the transferring attorney for collection of occupational interest, if it happens that the purchaser moved onto the property already. Party signed all the documentation, received cancellation figures, control stipulation of title deed, and draw up final title deed. Request guarantees from bond attorneys, and then it goes to receive guarantees, send guarantees to cancellation attorneys of the present bondholders, control the balance of the purchase price, and make arrangements for, if necessary. Cancellation attorney receive guarantees and send it to the financial institution for approval. And cancellation attorney receive the guarantees and send to financial, that's for approval, yes. Financial institution sign and return to the cancellation attorney. Then it goes to the pays outstanding rates and taxes in order to receive the clearance certificate, and then the attorney pays the transferring duty. After that, the cancellation attorney informs that they are ready to lodge. Cancellation attorney organized with bond and transfer attorney for lodging at the deeds office. Lodging at then the actual lodge at the deeds office all together. Deeds office, micro, distribute, junior, senior, head. I'll go with you through this process. Just now, I've got the explanation on the last slides. Attorney, prep, control, finances, look for definitions, agents, commission, etc., property registration, and then it is the present guarantees, do settlement accounts for the parties. From there, the seller vacates the property, buyer tax occupation, inform the municipality of new owner, request surplus taxes, wait to receive the title deed back from deeds office, send title deed to bond account to a bond attorney to the relevant parties, finalize the rates and taxes outstanding, and that is the reconciliation, actually, acknowledgement of receipt of documents from the persons involved, and then they close the file. Is everything clear here? Any questions?
Hi, Rina.
Yes, Kabela.
How are you, ma'am?
Fine, and yourself?
Good, thanks. In the event where there's suspensive condition, right? But
yes,
the suspensive condition does not stop the sale. Let's say for example, you wanna buy a property. Extreme example, where there's an extension, on the property, but it's not on the plans, and the seller is saying that they'll get the plans approved and everything, and you want to buy the house and put the suspensive condition that the seller will get the plans approved eventually and everything like that. Does now this attorney holds a portion of the money until those suspensive conditions are fulfilled, or how does that work?
Okay, it all depends on the financial institution, on your conditions of how your bond will be approved. If the bond is approved, as you say now, that you've put it in a suspensive condition, remember, it's a condition that gives you the right to cancel the contract. So the financial institution will also cover them with your condition, saying that transfer can only take place once that condition has been fulfilled. So meaning that if it's building plans, for in case the registration attorney, even if your bond is approved, all the documentation is signed, he cannot register unless he's got the building plans.
Okay. So then, should one take occupation, it would be on that, I just forgot the term, but on a rental basis, of some sort, I forgot that.
Yeah,
that
it's
term.
occupation, or you take occupation prior registration, and it is always very risky to take any occupation if a suspensive condition is outstanding. Because what if the purchaser decides, oh no, you know what, this is slip for me, I'm not going to do this plans, then you've got a suspensive condition, and then actually your contract lapses immediately, and you cannot actually claim from the seller.
Yeah.
Because it was a suspensive condition. You can, however, try to enforce it. There is ways to enforce it, like with the mora clause. The mora clause said that the party who holds up the registration process can be fined interest or an amount per month, per day, actually.
Okay, thank you for that.
So you can try to enforce it, but in general, a suspensive condition, if it hasn't been met by a certain time frame, then the contract automatically lapses. So in my instance, what I do is I never let any buyer moves into a property unless all the suspensive conditions has been met.
All right. Thank you.
Pleasure. Any other questions? Okay, this steps here is also just the same as exactly what we spoke about earlier. Step 4, step 5, step 6. So that is the total registration process, exactly what we said. And then activity, documents to be signed. During the bond registration process, there are several documents that have to be signed according to the law. Column A represents the types of documents to be signed. Column B represents the description of the documents. You have to match column A with column B. Authority of payment. Power of attorney to mortgage, letter of grant, draft mortgage bond, affidavits, suretyship, cession of life cover. I just want to see the next page. Okay. Okay, authority of payment. Let's read this column B. Should life cover be required by the bank, the client cedes an existing policy or takes out a new policy. Which one will you say is it in column A? It looks for me like the last one, cession of life cover. Do you agree?
Oh, definitely. Sorry, are you saying it's number 7?
Number?
I thought it was number 7.
Cession of life cover. Should life cover be required by the bank? The client cedes an existing policy out of a new policy.
Okay.
Yeah.
Sorry,
So I was. Yeah.
I thought we were on A. Yeah.
Yeah. Okay.
Yeah, for 1.
Okay. Now let's say this confirms the client's personal particulars regarding marriage and insolvency.
Affidavits, E?
Affidavits, each party lets, I think it's the affidavits, required when a client needs a guarantor for the loan.
Suretyship, isn't it? Suretyship.
I think it is suretyship, you are right, yes.
Yes.
Instruct the bank on the registration to make payment of the borrowed funds. That's number A, I'll say authority of payment.
Yes.
Okay, this is the document that records the client's financial obligations to the bank in the deeds office.
draft of mortgage bond?
Yes, I agree. This document gives the attorneys the authority to register a mortgage bond on behalf of the clients in favor of a bank.
Power of attorney.
Yes. This is the terms and conditions of the bank where upon signature the clients acknowledge its obligations to the bank.
Letter of grant.
Pardon?
C. Letter of grant.
Yeah. Okay. Now this is example C6. What is C6? Sorry. Oh, you must just write it in the A and towards that other number.
Yeah.
Okay. The parties involved, this is a self-assessment. Do you know who appoints the transferring attorney?
Is it the seller?
Yeah, he's got the right to appoint the transferring attorney, and don't let anybody tells you that you know the purchaser or an agent can appoint the attorney. You can advise, but you are not allowed to appoint. Okay, do appoints the bond attorney.
The bank?
The bank where the new bond has been, okay? That is the thing. It's the new bond. Who's appointing the cancellation attorney?
The bank.
Also the bank, and that is the bank where the seller has his loan. The old bond, I can say that. Any other questions? Okay, cost incurred during registration. Buying a house is exciting but can also be daunting. Many people do not seek professional guidance before entering into an agreement. As a result, consumers later discover that they cannot afford the bond repayment. That is why it is so important that you have to take the client out and you have to go through everything with the client before he signed the offer to purchase. Okay, the National Credit Act helps to promote a fair and transparent marketplace where customers can assess credit. The Act also encourages the bank to conduct an affordability assessment. First-time buyers need to be aware that apart from bond repayments, there are other costs involved in property sales such as deposit, bond costs, transferring duties, conveyancing fees, deeds office levies and fees, rates and taxes, bank charges, homeowners insurance, life insurance, moving costs, water bill, electricity and household cost. Deposit. Most banks require deposit when applying for a bond. The only time it is not required is when you are a first-time bond buyer. The deposit generally depends on the value of the property, but in most cases is 20%. Bond cost and transferring duty. These costs are always overlooked when purchasing a property and should be studied very carefully so that you understand how it's worked out. These costs amount to thousands of rands to make sure you know what they are, and as it will affect the total value of the property you are looking for. Conveyancing fees, transferring and registration fees. You have to pay the conveyancers, attorneys who register the property in your name, as well as the conveyancers appointed by the bank to register a mortgage bond over their property. The Law Society has recommended tariffs that the conveyancers may charge to transfer property into your name and register your bond. Deeds Office levies and fees. The Deeds Office is a government office and falls under the Department of Land Affairs. There are offices all over the country and they are responsible for the registration of property and other rights in immovable property. Rights and taxes. Property cannot be transferred from one owner to another until the rights due to the local authority has been paid in full for the full financial year. The seller is liable for rights only for the part of the year during which he or she occupies the property, in addition to pay a pro rata proportion of the municipality rates for the year. the buyer will have to charge for a rights clearance certificate, which is about, well, I said 30 rand. It's not. It's more money. I think it's 240 or something, right? Homeowners Association, when taking out a home loan, the banks will assist that you take homeowners insurance before the loan is approved. I don't want to teach you actually how to calculate these costs, because for the reason is that with the Consumer Protection Act, if you miscalculate one calculation on this, then you're going to have tremendous trouble with the purchasers. Either they can cancel the bond because it was misleading, or they can go ahead and you can be cut out with a commission. There's so many stories that I can come up with. That's why we prefer that you use the Uber app. It is just a maximum of 5% calibration that's be out. But if you take the internet data streaming, then you know it's not that much. So that is better to use that, because then you can fall back and say, but there is it where I'm getting my information from.
Rina?
Any questions? Yes, Kabela.
So the Uber app and all other apps, in the exam, will they allow us to use internet, or we'll have to scramble?
Yeah, it's an open book. It's an open book exam. I didn't want to declare it earlier.
So, because you know, in varsity, open book is limited to hard copy. So in this instance now, internet is something else.
Yeah, you can allow, I can do it.
All right.
Yeah.
Then, just a question on these calculations, because remember when we do these calculations, we use interest rate, right? So now many agents are preaching that this is the cheapest bond ever, everything like that, because I think it's 7% or 7.5, right? So
Yeah.
now, in the event that you get the bond at the rate of 7.5, can you make that to be fixed? Because come next year, June, everyone will forget the pandemic, everything shoots up. Then when you bought it, you could afford it, but now it's at 11.3% and you can't afford it. So is there a way a client can fix that 7.5, or how does that work?
Yes, you can. Actually, I think who spoke to us the other day that said that they advised that we fix. I think it was what then Alma was talking about it. I think that they advised that we start to consider fixing, because apparently the forecast is that the interest rate will stay as it is for at least another 6 months to a year. And that is to help the people to you know, get themselves in order again. You must remember, most of the people has been qualified on the old interest rate, so obviously they will still qualify even if the rates goes up a little bit. It's only for the people that qualifies now as the first-time buyers that one must look and see what is going to happen. But for the current bonds, they advise that you can fix the bond now, but the bank doesn't fix on the 7% that is currently running. They might consider, depends on your portfolio, to fix you at like 8.5% to 9%. It's like 1.75 to 2% more than what the current rate is. But now, if you must think of the long-term saving. If the interest rate goes up again to 10%, it's still a good opportunity. But I think it will be from person to person, and I will suggest that if you have a bond, talk to your go to the bank and talk to them and ask for advice.
All right, thank you.
Any other questions? Okay, the role of the attorneys. Contracts of sale usually state which party conveyances are to attend to the transfer of the property, pre-printed documents used by estate agents normally state that the seller is entitled to nominate the conveyancers. Frequently, a seller does not know any conveyance, and the estate agent who negotiated the transaction is asked to recommend a firm of attorneys. While an estate agent may be recommended a particular attorney, conveyancer, or supply names of various firms, he must always observe Clause 7.1 of the Code of Conduct. This provides that an estate agent may not, without good and sufficient cause, directly or indirectly, in any manner whatsoever, solicit, encourage, persuade, or influence any party or potential party to a pending or a completed transaction to utilize or refrain from utilizing the service of a particular attorney, conveyance, or firm of attorneys. And this also includes bond originators. We are not allowed to say that you have to, or the purchaser have to use a specific bond originator. It is the right of the client to choose, and that is part of the Consumer Protection Act. On another note, if you advise the transferring attorney or advise the purchaser to use a specific transfer attorney and something went wrong with the transaction, that purchaser can keep you liable under the Mora clause because the attorney didn't perform the way that you maybe said they will perform or that was expected from them to perform. The transferring attorney are attorneys with the qualifications to specialize in property law and who have been admitted to practice by the High Court. Conveyancers attend to property transaction, mortgage bonds, and other issues affecting fixed property. The seller advises the transferring attorney to transfer the property into the buyer's name. The title deed and cancellation figures are requested from the bank that currently has a home loan over the property. If applicable, a statement of rates and taxes requested from the local authority. The home loan attorney advises the transferring attorney of the amount available for guarantees and requests the draft deed of transfer and guarantee requirements. Cancellation attorney. A cancellation attorney is requested to cancel the seller's home loan upon receipt of a guarantee for the amount owing. The cancellation attorney. Yes, sorry.
Apologies.
Yes.
I don't know if it's just me, but there's a black thing that covers the heading on your screen. I don't know if it's just on my end.
No, this is the Teams heading because I'm not on my two screens. And I was looking now, how can I take it off? And I can't take it off.
Oh, okay.
There is gone. There is gone.
It's better now.
Right. Thank you.
Okay. But I must say, I'm in Bethlehem and the network is actually quite good. I don't know if you can hear me properly.
Perfect. You must find us landed there in Bethlehem.
I think so. Because there's no problems from this side. Okay, the cancellation attorney is requested to cancel the seller's home loan upon receipt of a guarantee for the amount owing. The cancellation attorney obtains consent from home loan cancellation from the bank which holds the seller's home loan. And there is like three attorneys. The one is there's a cancellation attorney, you get the registration attorney, and then you get the bond attorney. Okay, required documentation. This is from this slide. I will say the only real information that you must study very well is the required documentation.
Sorry.
Yes, Kabela?
Let's go back to the last slide. The cancellation attorney.
Yes.
So the cancellation attorney is only appointed when there's currently a bond on the property that's being sold. If the property is not bonded, then we don't need the cancellation attorney.
Yes. If there's no bond on the attorney, and also remember the bank appoints a cancellation attorney.
Okay.
In the old days, the one attorney can be the registration, cancellation, and bond attorney. But because of all the frauds, there's a new, I don't know if they can call it a law in the bank industry or is it just a regulation, But each, normally it's now three companies involved. And that's why I think they say that we've got in South Africa the best registration process.
So these cancellation fees are at the seller's expense with the, let's say in the event now there's a bond, right? The seller's expense with the bank that holds that bond.
Yeah, that is the expense between the bank and the cancellation attorney. But yes, it gets, the seller will pay for it. That's why it's very important, if there is a bond, for you to advise your sellers, inform your bank to say that you are going to sell. Because if the bank has been informed, then they don't pay a penalty. But if the bank is not informed, there is a penalty. And I can assure you, I've seen a penalty for about 25,000 rand on a bond of 800,000. So the bank is really harsh on the people on the cancellation penalties.
Yes, so in the event that you inform your bank that I'm planning to sell, I've went through the process before, they give you some sort of a PIN number or whatever for you to code whenever someone purchases. Is there a lapse period for that? Or you just inform them?
3 months. 3 months. Every 3 months. Yeah. That's why it's always good to send them an email as well.
Okay.
You can call them and ask them for a reference number, and then you send the email with the reference number so that you've got proof that you actually did tell them to cancel the bond. Every 3 months till the property is sold, and then you can actually take that emails and give it to the registration attorney and say, listen, this is my, I've informed my bank I'm going to cancel, or the cancellation, and they must make sure that there's no penalties before registration. They must sort that thing out before registration. Because once the bank issue that guarantee thing to say how much money they want, then it's trouble.
All right. Thank you very much.
Okay, was it clear, Camilla?
Yes, ma'am.
Okay. Any other questions? Now, required documentation is very similar than our FICA documents. This is an application form, is only a small part of the documentation required to initiate a new home loan application. So this is the standard FICA documents. We've covered this so many times, what you need. Do you want me to go through it again?
No,
Let's just do the first. It's actually very clear. Let's go through the company and close corporation. And I'm doing this because I think most of you are going to be developers one day. So you are going to apply on a company name, and so you need a copy of the latest financial statements. The banks are very, very clear on this, is that if you are a new company, you must remember you in person will also be liable and be held accountable for the bond. So there you will have to have, I will say, double statements, your personal statements, even if it's your own company. Remember that you must not live out of your company's bank. You must pay yourself a salary in person, and you must live from your own salary, and the company will be run from their bank account. So it's important to have the details of all the directors and members, founding statements, the closed corporation or company certificate, memorandum of articles of association, 6 months personal and business bank statements, resolution. This is the resolution. Yes, it's nice if there's a lot of directors, but remember, even if you are all by your lonesome self, you have to issue yourself a resolution to sign on behalf of the company. Role of the Deeds Office, the Chief Directorate, Deeds Registration is in charge with the administration of the land registration system, including the registration of rights to land and other matters prescribed the Deeds Registers Act. Activity, the deeds office, you will be divided into groups. Okay. How many offices does the deeds office have in the country? Let's guess.
If I have to guess and say there's one in all the provinces, can we say maybe 9 deeds offices?
Yes, I agree with you, Alex. I think it's one per in each area. Yeah.
Okay.
What is the mandate of the Chief Director of Deeds Registration? Is to register the property in your name. Name the act that regulates the Deeds Office. Deeds Registries Act.
Okay.
And the Sectional Titles Act. But the Deeds Registry Acts, I think this is the answer that they're looking for. But look, when was it? The act actually is 1937. Oh my word. Okay. Functions performed by the Deeds Office. The core business of a deeds registry is to maintain a public register of land as well as an efficient system of registration calculated to afford security of title to land and rights in land. Access to registration information for the general public, financial institutions, local authorities, the conveyancing freighter, the restitution, the redistribution and tenure reform directorates of the department, as well as the public land inventory. Functions of the Deeds Office is the registration of real rights in land, maintenance of land registers, provision of land registration information, preservation of registration records for archival purposes. So I just want to answer this SMS. Okay. Any questions up to here?
So far, so good.
Okay. And all the deeds of these registers are linked to a computer network. And this is public knowledge. If you can access like Lightstone, Windeed, any of those platforms, you can access the information. The only thing that they do not give out anymore, they close those features, is the personal details of each owner. So if your property is in your personal name, I can see your name, but I can't draw your cell phone numbers and email addresses anymore. Okay. This is also part of the Deeds Office. Okay, what I did is I'm going to reload this one, Cabela. I'm going to send you this one. Please, will you just change this one with the on the LMS for me, please? What I did here is I've added the Deeds Office property registration procedure. This is the procedure as when the attorney lodges it at the Deeds Office. This is the process. It currently takes around 7 to 8 working days for registration. Now, don't count on this. It can take from 7 days up to 21 days. I think currently it's like 10 days. So it depends on backlogs and stuff like that. Day one is the lodgement. Now, what happened when it's lodged? The lodgement of the deeds are checked by the lodgement clerks. Make sure that all the documentation is in there, everything is being recorded. Lodgement clerks are responsible for the data capture as well as linking of the deeds. So meaning they capture the actual deed. After checking, the deeds are sent to what they call DOTS, Deeds Office Tracking System. So there they track your the title deed. They make sure that whatever the attorney said it's there, it's there. So it's a total checking process on the first day. On the second day, sorting of deeds on what they call on a junior level. Deeds are sorted and distributed to various examiners for first examination. First examination are usually done by junior examiners. So meaning they make sure now, like for instance, if they want your ID first, and then they want your proof of address, and then they want the title deed, and then they want this, that it is in that specific order, and everything is there. Then day 3, sorting the deeds on a senior level. These are sorted and distributed to senior level. Senior exams may pass or reject the deeds. So when it comes there, it can be rejected if there's, say for instance, I think in COVID it happens a few times where your clearance figures are outdated. Then they can reject it. That's one reason why they can reject it. Final checking, assistant register monitors rejected deeds and decides whether to pass or reject the deeds. When a deed is rejected, it gets turned to the attorney and has to follow the entire process again. Deeds that have been passed are sent to the preparation room, what they call prep. I think, I don't know if how many of you heard that when we say yes, the registration are on prep, means that they are in the preparation room. The preparation of deeds are prepared by conveyancers and conveyancing clerks. The preparation process takes about 3 days. Final checks for interdicts are conducted. Why they do this is exactly what they say of the interdict. Say, for instance, there's maybe a second bond, or the property is now on, it must go on auction, or maybe it's an insolvent property. They make sure that everything is, or the money will go where it's supposed to go, and the registration can legally happen. Execution, deeds are executed, registered. After execution, the deeds are taken to numbering. Now, what does execution means here as well? Or what is the registration, what they call are executed? It is when the attorney goes there physically. Remember, the stamp, there's a stamp duty to be paid, so the attorney must actually go and post the stamps onto the title deed. And that happens on the executed date. So the attorney will go to the deeds office that morning with the stamps in his hand, and they will stamp the title deed, and they will sign it off there, and then it's registered. So it's an actual thing that must happen. Data capture, when it's done there, then it goes to the capture room, but then then the property has already been registered. This is now just an after administration process at the deeds office. It's not holding up the registration at the execution. On the execution day, money gets paid, commissions gets paid, everything happens on that execution day. But then after that, the deeds are added to the database. From this point, the information is available electronically and can be searched. Updating the registers, the deeds office registers are updated. Any questions?
Rina?
Yes.
Yes. My deed search dossier.za, is that public knowledge? Can anybody access the information on there?
Yeah, but I think you have to register. My deed search is the same as Windeed or Lifestyle.
Okay.
Yeah, it's a platform where you must be registered. But yes, then you can go in there and you can have a look as soon as it's been captured. Normally, it can take up to between 6 weeks and 3 months for this process. It depends on its backlog. The deeds office, pardon?
Is there a subscription service? Do you have to pay for it, or just
Yes.
name, surname?
No,
Okay.
it's a subscription service, but as I say, as a result of the POPI Act, they do not give out the personal information like your name. They will give your name and ID number, but that's all. They won't give your cell phone number and email addresses. That happened in the past, actually.
Okay.
So we are working on another process to access that now. Okay. The delivery, the deeds are delivered back to the conveyancer. So then the conveyancer, say for instance you bought the property cash, as soon as the process is finished by the deeds office, they will contact the attorney. All the attorneys, the conveyancers has like little post boxes at the deeds office. They will get your title deed there, and then they will call you and come and fetch the title deed. Some reasons why it sometimes takes longer for a deed to be registered is the degree of difficulty of the transaction. So it depends on what was in the old title deed. If the old title deed states that you cannot do raise 2 or 3 or 4 properties there, then you cannot open a sectional title register. Then they will throw it out. Or there's also, after 50 years, those clauses, specific clauses in a title deed lapse. Then the attorney must first redo the old title deed before they can do a new title deed. Too much workload for the examiners, incorrect information on the deed, backlog interdicts that have been uplifted, have to be uplifted. And that's basically the slides for tonight. Any questions? I think you're going to be very clever. We're going to get full marks.
Hey, Rina, this is you know. I think on the surface, you know, in terms of now practice, when you have to analyze the client and everything like that, I think it's manageable, you know. But now when it comes to translating this now in the exam, I saw the question that you just asked now to say which laws govern the deeds office, those acts that you just read out. I'm thinking about the number of acts that I've seen in these presentations, you know. So it will be a mammoth task, but nonetheless we will get there.
Yeah, but Kabela, you know what? I also told my own children that if you get into the exam and you get a question, place yourself in the position. What if, say for instance, I'm asking you that question now again. Place yourself on when must I use this act? When will this act be used? This act is going to be used in the deeds office. So obviously, it's the deeds office registry. Even if you don't know the year or whatever, at least you know the name of the act. And I think most of the questions is monkey puzzles. So if you would rather say it's a deeds office registry than to say it's a Consumer Protection Act or the Code of Conduct or whatever. Put yourself in the position where am I going to use it now? Then you get your answer. It's not really that difficult. I think it's the information is a bit too much at once, but you'll get it. It's easy. It's not that difficult. And we're going to go over and over it again. Okay. You can see the slides down. Let's quickly do evaluation. I think it's very important for you to know how does what we call a desktop valuation. Can you still hear me? I'm getting a message that
yes, we can.
Okay.
You can hear.
Okay, I battled to get into light stuff. Let's do property 24 there. And Kensington, is this a house, Alex? Or
Yes.
how many bedrooms plus minus?
The first one I sent you is 5 bedrooms.
The second one?
The second one, 3 bedrooms.
Okay, let's do the 5 bedrooms. is you also, apart from the Lightstone report, you go on the report and you look at the similar properties that might be available in that area. Now this one is a 6-bedroom, 4.5 bathroom for 274. Now how many bathrooms will you say is that number one for the 5 bedrooms?
4 bathrooms.
4 bathrooms.
Yes.
So there you get a very similar one, although 6 bedrooms, 4 bathrooms, 2.74. And there's another one, a 7-bedroom one, 5 bathrooms, 992 squares, and 1.9. 5 bedrooms, 2 bathrooms, 1599. There's another one, 11th Avenue. This is a very nice one. Oh my word. 11th Avenue, 4,154 squares and 2.3. Okay. Now the more property trends and statistics. If you click there, the network is very slow on the internet here. This is a good area, Kensington, eh?
Yes, it is.
Okay, there you can see the average price for the properties in the market currently is 1. Oh, that was the registration. The first two, remember, is a property that was registered. This is houses, and this is sectional title. So the average price there is 1.50, and this one is 121. The properties that's currently for sale, the new ones it's 162, the old ones it's 924 properties that's in the market in that area. We must concentrate there. There's 92 properties of 5 bedrooms for sale. So your 5 bedrooms is selling for